My Lord, may I make a mention, my Lord?
Yes.
Item number 11, my Lord.
Huh?
Item number 11.
Item 11.
My Lord, yes. My Lord, Lordship has suggested regarding if something can be compromised among the party. So on the last occasion, I have made a submission that on the 7th, the parties were to meet. So on the 7th, my Lord, with the division, because it's pertain to Joai, so there is some kind of a talk happen in which some positive development seems to come up. But now, my Lord, this matter has to be taken up by the head office, which is on Friday, my Lord, this Friday. So once the head office will consider, my Lord, we are hopeful that some development will be coming up. So, my Lord, I'm praying if this matter can be adjourned, because the meeting will be held on 23rd, my Lord, this Friday, in the head office.
Yes, what do you say?
I have informed my friend also.
I've been informed, Your Lordship.
On pre-made by the party, list this matter to 2 weeks.
My Lord.
Please, Your Lordship, I beg to mention item 10. Your Lordship, I pray that this matter come up after 2 weeks.
2 weeks.
What's this matter about?
Regularized session, Your Lordship.
So you don't want to be regularized?
That's on the difficulty of the Contempt Council, Your Lordship.
Since 2021, now 3 years have gone.
She doesn't have the qualification, Your Lordship.
Oh,
As
I
mandated
think this
under
matter
the
was
RT.
heard, wasn't it? Was this matter heard?
No, Your Lordship, it was not. Never heard.
On pre-made by the petitioner, list this matter up to 2 weeks.
Your Lordship, item 16 and 17 as well.
Who is he?
I'm for the petitioner, Lordship.
No, I mean,
Can you accommodate me 2 weeks, Your
on,
Lordship? Respondent number 6, Your Lordship.
on behalf of respondent.
Yes, Lordship.
You're for?
I'm for the petitioner, Lordship.
Any objection?
No objection. They were supposed to file their affidavits owing to the changed circumstances.
But
We were
this,
supposed to file the affidavit, my lord, and we have filed it on the 9th of August.
you have filed.
9th of this month, we have filed, my lord. We have some
From
copy.
one of the respondents we have received it, from others we are yet to receive.
Have you filed your affidavit?
They won't file
You
it
won't be filing, Lordship.
in this matter. In 260, WPC number 260, they won't be
Oh,
filing.
you are, yes, yes, yes. You are the NDCC. Is it this? Oh, no, sorry.
Ex-aim of Malay, my lord.
Yes. Now I recall. So how long?
2 weeks, Lordship.
No objection.
On pre-made by the respondent number 6, seeking accommodation. The same not be objected to by the petitioner and the other respondents. That is adjourned. This is same after 2 weeks.
Obliged, my lordship.
16 and 17.
16 and 17.
Lordship, I'd like to mention item number 13, Your Lordship.
Yes, Mr. Joshi, can you?
Lordship, in this case, I was supposed to file compilation of judgment that I shall be relying, Lordship. If your Lordship remembers that the dispute was regarding the pension and interest to that area of pension. So I have compiled some judgments, Your Lordship. I'll file it by next week, Your Lordship, if your Lordship grants me time.
Have you sought the consent of your colleague?
I haven't, Lordship.
Who is here? This matter was heard, wasn't it, Mr. Joshi?
Yes, Your Lordship. The only
With regard to the pay slip, isn't it?
yes, Your Lordship.
That calculation of the
Yes, Your Lordship.
Pay.
Yes, Your Lordship. So the only left is now with the dispute that we are claiming some interest on the area of pension. As your Lordship remembers, last time your Lordship had directed me to file some judgment if I'm relying on. So I'll just file it. I have complied made a compilation of some judgments which I shall be filing next week, Your Lordship. Kindly grant me 1 week time.
On pre-made by the petitioner, this is matter up to 2 weeks.
Deeply obliged, Lordship.
Please, Your Lordship. Lordship, I beg to make a mention of item number 9.
My lord, the conducting counsel E.H. Karmalang is indisposed, my lord. Kindly have the matter after 2 weeks.
On premium by Mr. Leonard Counsel, Leonard G, appearing for the respondent number,
State respond. Orders.
appearing for the state respondent, seeking accommodation on the ground that the Leonard conducting counsel is indisposed, the same not being objected to by the petitioner, matter is adjourned. Yes, the same up to 2 weeks.
Deeply obliged.
Lord, item number 15. Item number 15, if this matter can come up after 2 weeks, madam.
You are appearing for?
I'm for the school, Assam Rifle Public School, madam.
Who's for the petitioner?
Petitioner, Sir Asu is there. He's not here, I could not find him.
Have you sought his consent?
My lord, I could not find him actually, not his junior also.
Let the matter be called up.
My lord, obliged.
Daily list, item number 1.
Yes, Mr. Shulai, I think this item number 1 to 7,
Lordship, yes.
though it involves a number of parties,
Lordship, yes.
we would be practically discussing the same issue
Lordship.
Yes,
as to whether the
yes,
old court or the new court.
my
Until
lord.
that, you see, that issue is settled, we cannot proceed to the matter. So we'll hear the parties. Whoever feels that you can contribute, you can do so. But let me remind the council
My
that
lord.
we will be, this court will deal with this issue only with regard to bill applications.
Bill application, your lordship.
Because you see, there are certain, provisions in the old code, new code, which
lordship, yes.
has created some confusion. Somebody was raising the issue of the implication of whether a statement under 313 could be considered under the new code, all those things. But that would be a matter of trial. That would be for the competent court to take up the issue. So we'll confine ourselves only
My
to that
lord.
aspect.
Relating to
Bail matter.
pre-arrest bail only, your lordship.
Pre-arrest bail application.
Lordship, yes.
So tell me.
Okay, I start, my lord, with my case. My lord, in my case, I filed an application under the old code, pre-arrest bail. What happened in this case, in my humble and respectful submission, my lord,
Yes.
my application or the application of the petitioner is maintainable under the old code, even though the new code came into force. On the following ground, my lord. First, the incident happened on 27/4/2024. FIR was lodged on 1/5/2024. And case was also registered under the old code, under the IPC, offence under IPC. And however, my application for anticipatory bail was filed after the new code came into effect. So in my humble and respectful submission, my lord, the section 531 of the BNS clearly says that pending appeal, application, trials, inquiry, or investigation. trial or investigation shall be disposed of or continue as the case may be in accordance with the all provision of in accordance with the provision of CRPC, my lord. My lord, we have the section 531.
Yes.
If I may read 531.
Yes, yes.
2A. If immediately before the date on which the Sanhita come into force, there is any appeal, application, trial, inquiry, or investigation pending. Investigation, my case fall under the investigation. Then such appeal, application, trial, inquiry, or investigation shall be disposed of, continue, held, or made as the case may be in accordance with the provision of the Code of Criminal Procedure 1973. As in force, immediately before such commencement hereinafter refer to other said court, as if the Sanhita has not come into force. All notifications, publish, proclaim, issue, powers, confer, forms, provided by rules, local jurisdiction, define, sentence, pass, and other rules and appointment not being appointment as special magistrate made under this code.
This is not relevant.
Not that much. So my lords, in my case, the investigation is still going on. So it will fall under this 2A of the section. So this this provision covers the saving clause saves my case. It is maintainable under the old law. And in support of my submission, my lords, I have two citations held by two different high courts. First, Allahabad High Court. But it is not regarding bail application. However, my lord, there was an observation made in paragraph 8, page 4. Paragraph 8, my lord.
Yes.
It starts from the 1, 2, 3, 4, 5, fifth line of the paragraph. Therefore, if FIR is registered before commencement of new criminal law, then the procedure of investigation will continue as per the CRPC, because investigation will be deemed to be commenced on the date of registration of FIR. However, in case the FIR is registered after commencement of the new criminal law for the offence committed prior to the enforcement of a new criminal law, then the FIR would be registered under the provision of the IPC, as the IPC is a substantive law which was prevalent at that time, at the time of committing of the offence, because as per the Article 20 of the Constitution of India, a person can be convicted of an offence for violation of law enforced at the time of commission of the articles of the Act. Article 20 of the Constitution of India read as follows. My lord, I'll skip to another paragraph, paragraph 10.
Yes.
From a perusal of Section 6 of the General Clause Act, it appears that the repeals of CRPC shall not affect any investigation, legal proceeding, or remedy in respect of any liability, penalty, or punishments accrued or incurred under the Repeals Acts, and such investigation, legal proceeding, or remedy will continue under the Repeal Acts. It is also clear from Section 6 of the General Clause Acts, the repeal of IPC or CRPC will not affect any right, liability accrued or incurred under the Repeal Act. Therefore, despite repealing of the IPC and the CRPC, liability to get punishment under this IPC will continue, and remedy like an appeal under CRPC will remain as it was. The forum of appeal, being procedure in nature, will be as per the BNS. Paragraph 15, my lord.
Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. From the line 10 line below. However, in case the offence is committed prior to the enforcement of a new criminal law, the FIR is also registered prior to the enforcement of a new criminal law, then the procedure of investigation would be as per the CRPC. In view of Section 5312A of the BNS, therefore, the procedure of investigation provided by the circular dated so and so of the police service is also absolutely correct. Then secondly, I have another citation, my lord, which is held by the Rajasthan High Court. Second page, my lord, paragraph 6. If I may read, my lord.
Yes.
Paragraph 6.
Paragraph
Paragraph 6, second page 3.
6.
Page. The reason for the same are not far too sick. What has been seen simply is the date of registration of the FIR and the law as applicable as on the date of such registration. Right, it may sound, but settled position is that the moment an FIR is registered under the Section 154 of the CRPC, criminal investigation administrative machinery is set in motion under the Chapter 3 thereof. Thus, if an FIR is registered prior to 1/7/2023 under the CRPC, it would amount to a pending inquiry investigation within the meaning of Section 5312 of the BNS, my lord. Then further, my lord, page 5 of 8, second paragraph, page 5. From the word furthermore, my lord will have. From the word furthermore. Furthermore, right saving clause, the litigant already in legal proceeding. Second paragraph from that page 5 of 8.
It falls under paragraph?
Second paragraph. Furthermore, from the word furthermore. Second paragraph.
Yes.
Furthermore, right saving clause, the litigant already in legal proceeding initiated under the old code have been thus assured that their cases will be resolved under the legal framework they were initially engaged with. Saving clause does ensure that the repeal of old code does not create a legal vacuum, leaving ongoing proceeding in limbo. And to avoid such a scenario, the old legal process ought to continue seamlessly. 6.4, my lord, paragraph 6.4. Speaking of judiciary, why the saving clause which and saving dual approach, ongoing case to be disposed of under the old law and the ones registered after 1/7/2023 under the new code, even the code can manage their workload more efficiently. Judges and lawyers familiar with the old code can continue their work without needing to adopt immediately to the new provisions. Section 531 of the new Sanhita, while repealing the Code of Criminal Procedure 1973, simultaneously does safeguard the ongoing legal proceeding through its saving clause. 7, my lord. No doubt, criminal procedure can be applied retrospectively, subject of course of the judicial review, but in view of Section 5312A of the BNS, herein it is amply clear that all the pending matter prior to the coming into force of BNS 2023, as specifically mentioned in Section 5312A of the BNS, shall continue to be governed by the old code, that is the CRPC 1973. Therefore, pending petition in hand also has to be treated as under 438 CRPC. So, my lord, these are the citation in support of my contention. So, in view of the fact that my case investigation is still pending, so I would humbly and respectfully submit that old code will be applied in my case. or bail of the petitioner. That is my submission.
Yes, Mr. Shilai.
May it please your lordship. Lordship, I think in this present case, your lordship, there is no quarrel because, lordship, the language employed in section 531 is very clear, your lordship. Only pending, it is the admitted fact, your lordship, that the investigation as on today is pending. So, your lordship, I'll fall in line with what the
Yes.
it's pending, your lordship. So this, the fact of this case, your lordship, in my humble and respectful submission, your lordship, this bill application under 48 would be maintainable, your lordship, would be maintainable because as I have submitted, your lordship, the investigation is pending, so it has to be filed under the old act, your lordship. Kindly see, your lordship, again, if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry, or we are dealing here, your lordship, investigation, then such lordship, we skip appeal, application, trial, inquiry, then we come or investigation shall be disposed of, continue, held, or made as the case may be in accordance with the provision of the CRPC. So it's very clear, your lordship.
Yes.
But lordship, if the police, however, if the police file the charge sheet, your lordship, when the investigation is complete, your lordship, then the trial will, so far the trial is concerned, your lordship, the BNSS will come into play, your lordship. It will come into play, no more under the CRPC, your lordship. That is what the Punjab and Haryana High Court, your lordship, has said. Then lordship, kindly come to 8.9. There is yet another facet of the matter which creates
Just a moment.
lordship. Para 8.9, your lordship.
Yes. Please read out.
Lordship, there is yet another facet of the matter which grave attention of this court. Section so-and-so postulate that any appeal, application, trial, inquiry, investigation which is pending immediately before the date on which this Sanhita come into force, the same shall be disposed of continue or made as the case may be in accordance with the provision of the CRPC. However, there is no reference to revision in this provision. The Honorable Supreme Court, which deal with the saving provision of Section 484 of CRPC 1973, their corresponding provision of Section 531 in this case of P. Phillips Supra has held that the word application as used in section so-and-so will include a revision as well. Further, relying upon the judgment of the case of so-and-so, a full bench of the Patna High Court in the case of Ladu Lal Sahu has held that the word application in section so-and-so include within its sweep a petition of complaint as well as ruminated here and above the provision of section 4 of the BNSS and section so-and-so of the and section 4 of the CRPC 1973 and section 44 of the CRPC are akin in nature. Hence, the ratio This item D of this judgment shall apply into to the provision of BNSS. Judicial notice as can be taken off of the fact of more often than not application and petition are based interchangeably in pre-filed by rebel parties. For instance, in our High Court, application for bail is termed as petition. Hence, on the above analogy, Section 531 of BNS would apply to petition as well. Therefore, it is inevitable conclusion that petition of complaint ordinary referred to as complaint before the magistrate revision of petition, which are pending before the date on shall be disposed of, held or made as the case may be in accordance with the provision of the CRPC. In other words, the provision of shall apply to revision petition. Petition also petition of complaint only referred to a complaint with the same record as it is statutorily mandated to apply to appeal application trial or in terms of Section 31. So, Your Lordship, in this case, Lordship, from the first paragraph, Your Lordship, is done the if any investigation is pending, Your Lordship, is pending, then what they are, in my understanding after reading this judgment, it's it has to be made. If the investigation is pending, then application here, Your Lordship, pre-arrest bail application, it has to be filed under the new code and under the old code, Your Lordship. This is my understanding after having read the judgment of the Rajasthan High Court, Your Lordship. But, Your Lordship, in another judgment, Your Lordship, Lordship, after going through this judgment of the division bench passed by the Rajasthan High Court, then Lordship, another judgment from Rajasthan High Court. Lordship, kindly come to para 7 of that judgment. This is also a single bench, Lordship. Para 7, Your Lordship. No doubt.
This is the one, Mr.
No, Your Lordship. This is from Rajasthan. This is from Rajasthan, Your Lordship. Rajasthan High Court. This is a single bench judgment.
Which I cited is Allahabad High Court.
Lordship, this is regarding
Para 7.
Lordship, yes. Kindly see para 7, Your Lordship.
Yes.
No doubt.
Yes. Please.
No doubt, procedural laws can be applied retrospectively, subject, of course, to the judicial review. But in view of Section 531(2)(a) of the BN, it is amply clear that all the pending matters prior to coming into force of BNSS 2023, as specifically mentioned in so, shall continue to be governed by the old code. Therefore, the petition in hand has to be treated as Section 482, Your Lordship. Because why, Lordship, this? Because the registry of the Honorable Rajasthan High Court object, Your Lordship, to the file. If Lordship kindly come to para 1, this is the objection put by the registry of the Honorable Rajasthan High Court.
Yes.
SB criminal mispetition under Section 528 BNS for fair, impartial, and effective investigation in so-and-so, police station so-and-so, under so-and-so. A perusal of the above clearly revealed that the FIR was registered on so-and-so prior to coming into force of the BNSS 2023 with effect from so-and-so. So, Your Lordship, in para 7, Your Lordship, that objection of the registry of the Honorable High Court, Your Lordship, has been overruled by the landed single judge, Your Lordship, holding that it will come under the old court. Then, Lordship, there is another judgment also from Kerala High Court, Ernakulam. Lordship, kindly come to para 14 of that judgment. In this judgment also, Your Lordship, the Honorable Kerala High Court also has followed the ratio laid down by the Punjab and Haryana High Court, Your Lordship. That Lordship will find at para 14.
Yes, sir.
Lordship, yes. May I read it, Your Lordship?
Yes.
A learned single judge of the Punjab and Haryana High Court in X, versus State of UT Chandika and so after juxtaposing the provision of section so and section so, call out the following principle. As a sequel to the above rumination, the following principle emerge. The Code of Criminal Procedure 1973 stand repealed with effect first. Ergo, no new fresh appeal or application or revision can be filed under the old code on or after 1/7/2024. The provision of section 4 of section 531 of the BNS are mandatory in nature, as a result whereof any appeal, application, revision, petition, trial, inquiry, or inversion pending before 1/1/2024 are required to be disposed of, continue, held, or made as the case may be in accordance with the provision of the CRPC. In other words, any appeal, application, revision, petition filed on so and so is required to be filed under the provision of the BNS. Any appeal, application, revision, petition filed on or after so and so under this provision of the CRPC 19 is non-maintainable, hence would deserve dismissal, rejection on this ground, on this score alone. However, any appeal, application, petition filed up to so and so under the provision is maintainable in law. To clarify, in cases any appeal, application is filed up to so and so, but there is a defect, registry objection as referred to in common parlance and as such is cured, removed on or after so and so, such appeal application shall be deemed to have been validly filed and therefore would be non-maintainable. Section so and so shall apply to revision so and so as also referred to the with the same because as it is statutorily mandated to apply appeal, application, trial, or invention or in term of sections so and so. So, Your Lordship, this same judgment also speak of this more or less, Your Lordship, in the language used by the Honorable Rajasthan High Punjab and Haryana High Court, Your Lordship. Then, Lordship, another judgment, Lordship, that is from the Punjab and Haryana High Court again, Your Lordship. Kindly come to para 14, Your Lordship. Section 531.
Yes,
Para 14, Your Lordship.
14.
Lordship, yes. Section 531 of the BNSS explicitly, para 14, Your Lordship,
Yes.
specify that pending appeal shall be disposed of or continue as if the new law had not been taken following the provision of the CRPC. The petition and the accompanying application seeking an extension of time were filed and registered in the registry of the school when CRPC was in force and were pending on fast. Hence, they would fall under the scope of section 5312A of the BNSS Sanhita 2023. Therefore, based on the above, they shall have to be adjudicated under section 401 of the CRPC 1972 and not under section 442 of the BNSS 2023. Lordship, here the judgment it says, Your Lordship, that if you file the application prior to Lordship is say this is the case with regarding application for seeking for extension of time, Your Lordship, and it was filed, Your Lordship. It was filed when the CRPC was enforced. So the Honorable Delhi High Court, Your Lordship, says that, of the Punjab and Haryana High Court says that that has to be treated as an application under 401 of the CRPC because it was filed, Your Lordship. It was filed when the new act has not come into force. Then, Lordship, another judgment, Lordship. This is from the Honorable High Court of Delhi, Your Lordship. Prince. Lordship, kindly come to para 5. Lordship, it says like this, Your Lordship.
Para 5.
Para 5, Your Lordship. In the circumstances, since the present petition has been filed after 1/7/2024, in the opinion of this court, the present petition ought to have been filed under the BNSS, be that as it may, in order to obviate any unnecessary delay. The present petition is treated as one under Section 482, read with Section 528 of the BNSS. See, Lordship, here the Honorable Delhi High Court, Your Lordship, in spite of the fact that it has been filed under 1/1/2024, still the Honorable High Court, Your Lordship, the Delhi High Court, Your Lordship, treated that petition under Section 482, Your Lordship. Then, Your Lordship, another judgment from the Delhi High Court, Your Lordship.
Yes. This is an appeal.
Lordship, this is a criminal appeal, Your Lordship. This is an appeal. Whether shall I, because we are dealing here, Your Lordship, with the pre-arrest bail.
Please.
Lordship, kindly come to para 4 and 5.
Yes.
On a plain reading of Section 5312A of the BNSS, it is noticed that if before the coming into force of the BNSS, there is any appeal, application, trial, inquiry, or injunction pending, then such appeal, application, trial is required to be disposed of, held, made in accordance with the CRPC. In the present case, admittedly, the trial was conducted and completed under the CRPC as per the general settled principle of law. An appeal is considered to be a continuation of the trial. However, the wording of Section 5312A of the BNS is amendable to a possible interpretation that if an appeal is pending before the coming into force of the BNS, only then would such appeal be continued under the CRPC. In the circumstances, the question of whether the present appeal is to be entertained and dealt with under Section 374 or under Section 415 is left open to be considered subsequently. So, Lordship, can you see here also the Honorable Delhi High Court, Your Lordship, has, with regard to appeal, Lordship, has left that question open, Your Lordship, whether to be considered under the old code or under the new code, Your Lordship.
Just that these are again these are procedural law involved.
Lordship, yes. So, Lordship, to conclude my submission, Your Lordship, I would respectfully submit, Your Lordship, since I'm dealing with this case, Your Lordship. Since this FIR, admittedly, Your Lordship, it was filed prior to the coming to force of the new code, Your Lordship. In my humble and respectful submission, Your Lordship, as I have submitted earlier, the CRPC will hold the field, Your Lordship. Will hold the field.
Yes.
That is my submission, Your Lordship. Since Your Lordship specifically would like to deal with the question of pre-arrest bill only, so I'm confined to that, Your Lordship.
Yes, Miss. Tell me.
Lord, for my Lord, convenience, I prepared a table. I was hearing 1904 where a similar issue has been brought. There's a table that I've prepared with 8 orders of different high courts. If my colleague may do with the table.
Just will take it up now or?
What do we do? We'll take it up after DB. In any case, I think the court has substantially heard the matter.
Government cannot take different stands in different items.
I didn't say I'm going to take a different stance. My Lord wanted assistance and
Yes.
That's all.
I have made it clear right at the beginning that any assistant, any view would be accepted by this court, would be considered by the court rather, and then the court would take an overall analysis of the
A view, Your Lordship. Lordship will have to take a view.
That's true. But as far as the merits of these applications are concerned, all the bail applications that is listed today, the matter would not be.
That will have to be dealt, Your Lordship, after Your Lordship comes to a conclusion as to whether the CRPC or the BNS will apply.
We have an order of the High Court of Delhi, my lord, where it says, my lord, where my learned senior has also placed it, my lord, where it says, my lord, the law, keeping the law which provision to come, my lord, let the matter be decided on the merit, my lord, irrespective of coming under the old act or new act. That they have not given so much of importance.
Because you see, Mr. D,
In fact,
we are still under the view, rather, or we are still considering whether the procedural law pertaining to the old code or the new code will apply.
Absolutely.
Because that is the because some these petitions has to be disposed of under some provision.
Yes.
Either old or new.
Yes.
They may be similar, they may be applicable, not applicable. That is that is what we are deciding here, or rather that is what we are discussing here. So to take up the matter on because some of the applications have been filed under the old code, some have been filed under the new code. So we have to standardize that.
Yes.
So of course the court has substantially heard it, but then like I said again, any counsel is free to express his opinion. Mr. N has submitted this. You've just given me the list, but not the.
I would like to read out certain paragraphs, more paragraphs than what has already been read. If my Lord will like to take it up after the DB, it's fine.
So we'll take it up after the DB.
Apply.
Daily list item number 1.
My lord, in this case, the appellant has filed recently one affidavit, additional affidavit. I need to reply it, my lord. We need 2 weeks time, my lord. I am appearing for the FCI.
What is the matter about?
I am appearing for the FCI response.
What is the matter about?
My lord, I am the writ petitioner. This case was so there's two issues are involved. One is the petitioner was like blacklisted, debarred from tender work for 2 years, and number 2 issue was that, my lord, cost and expenses was imposed. They're trying to impose on us, my lord. So my submission will be in this case, my lord. So far the, my lord, debarment is concerned, I have got no grievance now because Lord Singh just giving me the relief. Ultimately, consequence will follow, my lord. I am not on that. The second point is, on the grounds which the terms and conditions of the NIT, whether they can impose cost and expenses on us, my lord. Risk and cost on us, my lord. That will be the issue to be decided by you. So last occasion 13.5, yes, lordship was
the cost that has been imposed.
Not even. They will impose, if there is no order, they will impose that on cost and expenses.
Who will impose the cost?
The FCI. The ground is, my lord, like that. Tender work is for transportation of goods in the FCI, which will start from the December 23 for 2 years. Here the tender work has not even started, but it says, their terms and conditions says, for the unexpired work. The meaning is, suppose if I start working from Guwahati to Shillong highway, my lord, suppose I am doing it. I do the work halfway up to Nongfu, and then I stop doing the work. Then the authorities, any authorities, will give it the same work to the other contractors. For that, from Nongfu to Guwahati, that work, that cost will be imposed on me. Here the point is, work has not even started. That will be the lordship will decide, my lord, ultimately. So I have given the example by an affidavit, example to 2 other cases where, in the similar ground, they have debarred, but no cost and expenses. Then what I have done, you are going to take actions on me for cost and expenses. That will be the ground. On that ground, they want to say they want to file affidavit, my lord. That's why they're making prayer on that, my lord. So there are 13.5.23, lordship was pleased to issue notice in this case, fixing the matter today, and interim order was still today. So my humble submission will be, lordship may grant him time, but till then, my lord, the interim order will continue, my lord. That's all.
Only thing, my lord, that interim order may be granted on merit, my lord. On what happened on last occasion, that
Hey,
is.
we have not even heard the matter.
Yes, my
lord.
lord.
Now you have come before this court seeking time to file a response.
No, I want one clarification, my lord. Your lordship, if lordship will kindly see the last order dated 13/5/2024. I think there is some typographical mistake. The second para, learned counsel appearing for the respondent herein submitted that the respondent have not preferred any appeal. It ought to have been the appellant, my lord. So that is creating problem that as if we have considered it. So department is cutting all up.
No, there is a point. There is a point, my lord. I let me clarify it. There is a point. See, my impeachment order has 2 parts. One part is debarment. I got relief. I got relief in court in the first. No, I'm not. Let me clarify why it is like that. So far the debarment is concerned, I got relief. Again, it is got against them. Against them, they did not file any appeal. So for the second part is concerned, I filed the appeal.
Yes,
the meaning of this respondent, they have not filed appeal in respect of debarment, my lord. That's the reason.
That is your submission. That's what I wanted to say. That ought to have been their submission, not the respondent submissions, my lord. So that is the difficulty.
So, which means to say that you have not conceded to the
yes,
fact
yes, my lord. Yes.
That you have not filed the appeal.
Yes.
You may.
Fact remains that you have not filed an appeal, isn't it?
No, we are not challenging the blacklisting part.
The single bench order has not been challenged by you.
Single bench order, the one part is in my favor. That is risk and cost factor. The court has not interfered.
You filed an appeal. The question is that have you filed an appeal or not?
No. Regarding blacklisting,
that question was asked by Honorable Chief Justice last occasion.
Whatever the case may be, it's just academic.
Yes, ma'am.
At this point of time, if you subsequently do, it makes no difference because that is your prerogative. You can do it at any point of time. You want to file an appeal, it's up to you. But if you
actually they have challenged the order of one for the blacklisting and one for the risk and cost.
That is the
learned single judge has not interfered with the risk and cost factor. They have come up with appeal regarding this risk and cost factor.
Exactly.
And regarding debarment, we have accepted it and we have issued another so cause notice as per the direction of the honorable learned single judge. But for the risk and cost, I need not file an appeal. So what has happened that it ought to have been the submission of the appellant, not the respondent. That's what I am wanting to point it out. Learned counsel, it can
even if we change at this point, what does it matter? Tell me.
No, it doesn't matter.
As far
But
as
my
this-
department
as
is
the-
saying that why you have considered. Actually, that was not the fact. That
it became personal.
You do not have to concede it. If it is a matter of fact,
Yeah,
you don't have to
but-
concede it. Record will speak for itself.
yes, my lord.
Yes, of course, sometimes these things happen.
Yes, my lord.
No, actually what happened, my lord?
Authority
Technically,
doesn't understand.
he was in the screen from Guwahati. He was on the screen. For one moment he was out, his junior was there. Honorable Chief Justice Lordship was there. Asked the junior, have you filed appeal? He said, no, he didn't file appeal. And that came out.
No,
Exactly. It's not that nobody was there. He was on the screen. And then...
Because of disconnection.
Yes.
You are Mr. Singh.
Yes, Miss B.K. Singh, my lord.
Mr. B.K. Singh, learned counsel for the... You are appearing for all the respondents?
All the respondents, my lord. Not for Union of India.
Oh.
226.
And what is your role here?
Nothing.
How many respondents are there?
7. I am appearing for 226, my lord.
2 to 6.
2 to 6.
Mr. B.K. Singh, learned counsel, appearing for the respondents 2 to 6, has submitted that the appellant has filed an additional affidavit before this court, to which response to the same is required, and accordingly some time is sought for these said response to be filed. Pray aloud. Mr. Nat, learned counsel for the appellant, has in the meantime submitted that till the next date fix, the interim order passed by this court by its order dated 13/5/2024 may be allowed to continue. Pray aloud. On prayer made by the parties, this is matter. You want to suggest the date?
My lord, on 12th this is possible, my lord. If not inconvenience to your lordship, 12th September, my lord. Because in our place, Guwahati also got that hearing days. We were little relaxed on that day.
Yes,
Can it be on 17,
my lord, my lord. Yes,
16 or 17. 16 or 17.
17.
September.
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 On prayer made by the parties, this is matter on 17th.
Obliged, man.
Obliged.
Item number 2.
May I please?
May it please your lordship.
Yes.
I'm seeking for some accommodation for today, your lordship. The conducting counsel, Ms. N.G. Shalla, she is indisposed, your lordship.
What is this matter about, Mr.
My lord, this matter with regard to the incorrect date of birth, and thereby I was prematurely released from my service, my lord. That is the issue, my lord. I filed a writ petition, and the Honorable Single Judge has passed the judgment and order dated 24/6/2024, and thereafter, my lord, I filed the instant appeal before this lord, Honorable Court, my lord. This is the issue, my lord.
You are in service. You
No,
were
my
in
lord,
service?
prematurely released, my lord. Released from the service, my lord.
Prematurely means according to you.
Yes, according to me.
But according to records.
Yes, my lord.
According to record.
Yes.
You have attained your age of superannuation.
Yes, my lord.
For which you have been.
Yes, my according
There
to
were
the
2 date of birth
yes,
recorded.
my lord.
Your
Yes, 2
lordship,
date of
in
birth
his
recorded.
initial appointment, your lordship verification rolled, his date of birth is 1964, your lordship. So based on that, it is calculated.
My lord, I was appointed in the year 1988, my lord, as motor mechanic. At that point of time, I was class 7 passed out. Then immediately after the appointment, I was asked by the respondent authorities to produce the school certificate.
Your lordship, he was never asked, your lordship. There's no...
My lord, as per the instruction of my client, and immediately on the same month, in the month of March 1988, I requested the school authorities to issue the school certificate. Thereafter, I have submitted before the respondent authorities to record the correct and actual date of birth in the service record. And accordingly, I was continuing in my service.
That has been, the request was made then.
My lord, then, my lord.
But nothing has been done.
There was no request, Your Lordship.
My
He
lord,
has no communication.
The records will.
yes, my lord. My lord, thereafter, the respondent authorities had issued time and again the service ID card with correct date of birth as per my school certificate. So, my lord, I was under the impression that my actual and correct date of birth is recorded in the service record, my lord. So, I was continuing in my service, and during my continuation of my service, the issue of recording of incorrect date of year 1967 is never surfaced. Neither they were issue any notice with regard to the same to me. So, all of a sudden, in the year 2022, in the month of May, they have issued notice of they have issued notice to the appellant for the retirement. Then immediately I approached to the respondent authorities, the SP of Receivable Para, with regard to the issue that my actual and correct date of birth is this as per my certificate and as per my service ID card. Time and again they have issued. Then they have sent that matter to the Lok Adalat, and during that period they have prematurely released me from the service. Then in the Lok Adalat I appeared, my lord. The matter was not settled. Then I was compelled to file a writ petition before this honorable court, and
Yes, Mr. Hassan.
Yes,
my brother was inquiring. You had approached. The matter was taken up before Lok Adalat.
Yes,
Why, how? In what way?
My lord, the SP of Receivable Para, since I have filed my application after receiving the notice, they instructed the appellant that the matter was sent to the Lok Adalat for settlement.
How can it be?
My lord,
a matter that is sent before Lok Adalat would be a pending, legal.
My lord is correct.
Case before court.
My lord, they have sent
departmental
it to
proceeding. Whatever happens in the department cannot be.
My lord, I am not aware that point of. They have sent it to the Lok Adalat.
Anyway, that's beside.
Yes, my lord. I have appeared before the Lok Adalat. Even I also they request me to appear before the Lok Adalat. Were set in the High Court next building, my lord. So in that I have not agree with the proposition made by the Lok Adalat and the state respondents. So agree by that I have filed
Anyway,
petition.
now today I think since
Yes, my lord.
The council has sought for
My lord.
accommodation, we'll take it up on the next date.
My lord. My lord.
What date do you suggest?
My lord.
After 2 weeks, Your Lordship.
My lord.
Any date?
1 week, my lord. If
2 weeks, Your Lordship.
Why 2 weeks?
Well, because my date of the actual as per the school certificate, that date will my lord, in the next year, my lord. Next year,
okay.
Because as per the record, my lord.
So if your case succeeds,
then you get all the entitlement.
You would still be.
My lord, yes, my lord.
In any case, even if you succeed later on, you will be given all the notional
consequential benefits, my lord.
Miss Jirwal Leonard Council, Leonard G has sought for accommodation on the ground that the Leonard Conducting Council is indisposed. The appellant not objecting to the same, matter is adjourned. This is the same on this 19th, 2nd February, September.
My lord, kindly on the 3rd, my lord, 2nd.
3rd.
My lord.
3rd September.
Highly obliged, my lord.
Item number 3.
Please, Your Lordship. Lordship, in this matter, I pray if Your Lordship may grant us a week's time to file objection, Your Lordship.
Criminal appeal, what objection is there? Because this is more or less a bail application.
In essence, it is bail, madam.
Except for the specific provision.
Yes, sir.
Section 21.
Section 21.
Mr. Leonard, counsel for the respondent has sought for time to allow the respondent, Union of India, to file a response to this application. On pre-meet, it seems long. How long?
A week's time, Your Lordship.
On pre-meet with the parties. This matter on 28th.
Okay.
item number 1.
I don't think this would be item number 1. It would be item number 1 to 7.
Yes, 1 to
Is
7.
it 7?
Item 1, we have already
1 to
raised
7.
the arguments.
I am for 2, my lord.
So, we are, again, I have to reiterate myself, we are only on the issue of
Only on
old
the
code, new code,
yes, my lord.
whichever is applicable.
Lord, I mean item number 2. My lord, if my lord will come to section 531 of the BNSS, my lord.
We'll come to you when we come to item 4. You are in item 4.
Item 4.
Who's item 1? Item 1 done. No, item 2. Yeah.
Yeah, Mr. Paul, you are in this case?
No, I'm in item 2. I'm for the petitioner. I'm for the petitioner.
Yes, so what is your submission? You have
Well,
filed
I
this
think-
application under old code or new code?
New code, Millets.
New code.
Millets. As a matter of fact, now what has happened is, Millets, your lordships are aware that there has been various high courts have taken various views. A division bench of the Allahabad High Court, Millets, in my humble submission, would probably have put quietus to this entire dispute. And they have issued certain guidelines, Millets. Court Master, do we have extra copy for it? I'll just share it. Paragraph 16, if your lordships kindly have a look. It's at page, internal page 9. The other high courts also just do it, so that will place it.
This is a bail application or writ?
Well, it's a
Bail.
criminal miscellaneous. This is an anticipatory bail application. My application is
No,
a
this-
no.
this,
This is a
another-
criminal miscellaneous writ petition, Millets. I think this will be under the 482 of the old code, Millets.
482
of the old code.
Exactly. That's what-
Paragraph 3 would clarify this, Millets.
Yes.
Millets, if your lordships kindly have para 16 at page 9.
Yes. Yes.
On the basis of the above analysis, this court is also summarizing the law regarding the effect of repealing the IPC, the CRPC by BNS and BNSS respectively. The same is being mentioned as below. If an FIR is registered on or after 1/7/2024 for an offence committed prior to 1/7/2024, then the FIR would be registered under the provisions of the IPC, but the investigation will be continue as per the BNSS. In a pending investigation on 1/7/2024, on the date of commencement of the new criminal laws, investigation will continue as per CRPC till cognizance is taken on the police report, or if any direction is made for further investigation by the competent court, then the same will continue as per the CRPC. The cognizance of pending investigation on or after 1/7/2024 would be taken as per BNSS, and all the subsequent proceedings, including inquiry, trial, or appeal, would be conducted as per the procedure of BNSS. Section 531(2)(a) of the BNSS saved only pending investigation, trial, appeal, applications, and inquiry. Therefore, if any trial, appeal, revision or application is commenced after 1/7/2024, the same will be proceeded as per the procedure of BNSS. The pending trial on 1/7/2024, if concluded or on or after 1/7/2024, then appeal or revision against the judgment passed in such trial will be as per the BNSS. However, if any application is filed in appeal which is pending on 1/7/2024, then the procedure of CRPC will apply. If the criminal proceeding or charge sheet is challenged before the High Court on or after 1/7/2024, where the investigation was conducted as per CRPC, then the same will be filed under 528 of BNSS and not 482 CRPC. Coming back to the facts of this case, so these are the guidelines that have been laid down, Millets.
Yeah, but these guidelines,
It would only have a persuasive value on your lordships.
but these guidelines per se would not apply as far as bail application.
My lords, it is there for application, my lords.
This is just a reiteration of the provision of.
No, but I will just take your lordship. The cognizance of pending investigation on or after so-and-so would be taken after BNSS, and all subsequent proceedings, including trial, inquiry, or appeal, would be conducted as per BNSS. Section so-and-so of BNSS saved only pending investigation, trial, appeal, application, and inquiry. Therefore, if any trial, appeal, revision, or application, this is an application, my lords, it's a separate power that your lordships have, is commenced after 1/7/24, the same would be proceeded as per the procedure of BNSS. So because two things, my lords, to my humble understanding, well, it's two aspects. One, 531, my lords, repeals CRPC. So CRPC does not stand anymore. Now, once, my lords, CRPC is done away with, it would have created a huge confusion across the country. So certain procedures have to be saved. We cannot say, my lords, simply because there was, my lords, a new code has come in, any investigation prior to that would have been rendered odious. That cannot be the position. So that has to be saved. So 531(2) would come in aid of that saving.
Exactly.
That saving, my lords, is only in respect of what has, therefore, paragraph 4, my lords, I think is very relevant, because it saves only these pending applications or pending inquiry, pending investigation whatsoever. If a fresh application, my lords, because 438 under the old code, and I think under the new code it is, anticipatory bail is 5, it's 482. We'll take some time getting used to these provisions. 438 has now become 482. So 482, my lords, is an independent power that your lordships are exercising. That is laid out from Gurbakh Singh.
Yes,
It cannot be curtailed by virtue of, my lords, anything that is there in the code. It is because it opens up with a non-obstant clause. Now, once that is the position, my lords, it is an independent proceeding altogether. CRPC as on today does not exist. So once it does not exist, my lords, I cannot invoke any provision of the CRPC. The power of your lordships to grant any bail as on today, insofar as anticipatory bail is concerned, is, my lords, under 482 of the new code. Because the bail will be effective as on date, my lords, it cannot have retrospective operation. From whichever date your lordships will consider, so there cannot be an occasion, my lords, that I invoke power of something which does not exist. That, in my humble submission, my lords, is the rationale. Otherwise also, my lords, your lordships are aware that the substantive provision will definitely continue to be under the IPC. But the procedural law, my lords, is always retrospective. It would be on whichever date I would have to then go under BNSS, because CRPC, for all practical purposes, as on today, does not survive. Now, all the other judgments, my lords, that have come, I must place it before your lordships. Where are they? Sorry? Where's Kerala? Because we've got the decisions of Rajasthan, Kerala, Punjab had taken
Have you made out a list?
I have not.
It would have been better, because why?
Yes.
You were not here just a while ago. Mr. Sulai has cited a number of
These, my lords, why I said Allahabad High Court would be of more persuasive value, because it is by a division bench.
It makes no difference.
No, my lords, in the hierarchy of things, my lords, it is a division bench which has taken a view. It's a larger bench which has taken a view, my lords.
True.
Because all the other decisions that I have seen, my lords, are all taken by a learned single judge of a High Court. So this is the first time probably why my lords, a division bench had the occasion to deal with it, and they've dealt with this. Of course, my lords, in so far as Rajasthan is concerned, Rajasthan has taken a contra view.
That's a DB.
No, single bench. These are all single bench.
Rajasthan, Delhi,
My lords.
Punjab, they have taken the view that.
Kerala has taken a different view, my lords.
Of course. Was it Kerala which?
Kerala has taken a different view.
That was Delhi.
Kerala High Court, the Honorable Kerala has followed the view of the Punjab and Haryana High Court, Your Lordship.
Oh yes.
What we could do is, my lords, if you're subject to what your lordships feel, I can make a small compilation of this along with a note and place it for your consideration for your lordships.
It would be much clearer.
My humble submission would be, my lords, that otherwise also, be that whatever is the objection, my lords, the fact of the matter remains, insofar as the power of anticipatory bail that your lordships are exercising, my lords, it is a independent power. Your lordships would be aware, because then I'll have to take your lordships back to the, my lords, what now would be the pre-old code, prior to the amendment of the CRPC. That time that power under 438 was not there. So, well, there your lordships have then the series of judgments which discuss how this power has come into being and how your lordships are exercising this power. This is on, well, it is a separate power that has been exercised by your lordships, and therefore, my lords, my humble submission would be that since as on today CRPC does not exist, it would have to be only and only under the BNS. If my application had been filed prior to, my lords, 1/7/2024, then it would be under CRPC and your lordships would deliver an order under CRPC. But as on today, that power your lordships is not available under the CRPC. It would have to be exercised only under the BNS. Yes.
Mr. Paul, what you can do? You have a contra view.
My lord, yes. My lord, the judgment which my learned senior has relied, Allahabad High Court, the Roman 4, my lord, paragraph, page number 10, my lord.
Where is it? Roman 4?
Roman 4, my lord, page number 10.
Para 16, Roman 4, my lords, what I had placed reliance on.
Yes, yes.
My lord, Roman 4, my lord, it says section 531 clause 2A of BNSS saved only pending investigation, trial, appeal, applications and inquiry. Therefore, if any trial, appeal, revisions or applications is commenced after 1/7/2024, the same will be proceeded as per the procedure of BNSS. Now, if my lord will come to section 531 of BNSS, it says, my lord, subsection 2, which says clause A, notwithstanding such repeal, if immediately before the date on which this censita comes into force, there is any appeal, applications, trial, inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with the provisions of the Code of Criminal Procedure 1973.
No dispute.
Now here, my lord, as far as this present case is concerned, the FIR and investigations has been filed, FIR has been filed prior to coming into this new censita, my lord, and the investigations has been pending. Now, as per section 531 clause 2A, my lord, if the trial or investigation is pending, my lord, that has to be disposed of or continued, held or made in terms of the old code, my lord. Now, if that be the case, my lord, all the applications has to be also filed under the old code, in my understanding of the provision, my lord. Now, there is another aspect to it, my lord. IPC, CRPC and the Indian Evidence Act, this comes in set. All the three comes together. Even this time, my lord, the BNS, BNSS and Bharatiya Saksha Adhiniyam, my lord, this has come in set. Now, the CRPC has a reference of IPC or Indian Evidence Act. It does not have reference of BNSS, BNS or this Adhiniyam 2023. Now, problem will be, my lord, if suppose the trial which is pending or investigation which is pending, my lord, prior to coming into this new censita, this, if the new code is applied, it does not have a reference of CRPC, it does not have reference of IPC, whereas the cases are continuing under old IPC, my lord. Now there may be confusions and there may be problem in implementation of this new code, my lord, if we apply the new code in cases where trial is already pending or investigation is pending, because these three codes, one has a reference of the other. IPC has reference of CRPC or Indian Evidence Act, vice versa, my lord. Similarly, my lord, this new code also has reference of BNSS, has reference of BNS and the other code. Therefore, my lord, if the new code is applied in cases which is pending prior, my lord, prior to coming into this new Sanchita, my lord, there may be lot of confusions and problem, my lord, in implementing this new code, my lord. That is my only submissions.
That is, you see, that is why that section saving clause is there.
Saving clause is there.
That is why.
And therefore, my lord, the saving clause clearly says.
See, to answer, a perceived dilemma.
Therefore, my lord, it clearly says the trial investigations which is pending, that has to be disposed of, continued, held in terms of the old code. Therefore, any applications, my lord, in those cases which are pending prior, my lord, should be in terms of the old code, my lord. That is my humble submission.
The only answer to this, what my learned friend is saying, well, is the answer lies in 531(2)(b. The difficulties that he's talking about, that also the law makes a provision that any references to the code, my lords, under the old code will mean references under the new code. I'll read 531(2)(b). All notifications, published, proclamations issued, powers conferred, forms provided by rules, local jurisdictions defined, sentences passed, and orders, rules, and appointments not being made as special magistrates made under the said code, which were in force immediately before the commencement of the Sanhita, shall be deemed respectively to have been published, issued, conferred, specified, defined, passed, or made under the corresponding provisions of this Sanhita. There is no difficulty in these aspects.
So regarding notifications and all, my lord,
absolutely, that's what you're talking about. So if there is any reference, my lords, the reference would mean a reference under the new code.
This does not involve trial.
The issue here is, my lords, that as on today, the old code does not survive. So only certain exceptions are there. If you've already started a trial under the old code, it will continue under the old code. I don't think there is any dispute or, my lords, difference with my learned friend on that. What I'm saying is, my lords, 438 under the old code, 482 under the new code is essentially a separate power that is exercised by your lordships. It is bestowed only upon, my lords, the Court of Sessions and your lordships. It's a separate power. So it is a new application. New applications cannot be under the old code because old code does not exist. And that is what 16(4) clarifies. Trial will very well continue under the old code. And that finds, my lords, the foundation of my argument is that any procedural law that is notified would be retrospective. The substantive trial or the substantive offence would be under the IPC. Very well.
As you read the provision of 438 under the old code,
my lords,
and 482
under the new code,
is there any difference?
No, my lords. I'll take your lordships to both.
It would be if it is paramaterial.
I'll take your lordships to both. I'll first place the old code and then the new code.
It's not same, my lord.
My lords, may I read? Where any person has reason to believe that he may be arrested on accusation of having committed a non-bailable offence, he may apply to the High Court or the Court of Sessions for a direction under this section that in the event of such an arrest, he shall be released on bail, and the court may, after taking into consideration inter alia the following factors, namely the nature and gravity of the accusation, the antecedents of the applicant, including the fact as to whether he had previously undergone imprisonment or conviction by a court in respect to any cognizable offence, the possibility of the applicant to flee from justice, and where the accusation has been made with the object of injuring or humiliating the applicant, by having him so arrested, either reject the bail application forthwith or issue an interim order for the grant of anticipatory bail. Now, under the new code, Millets, where any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offence, he may apply to the High Court or the Court of Sessions for a direction under this section, and that court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. Well, I think only those conditions at 1, 2, 3, 4 that have been done away with. When the High Court or the Court of Sessions makes a direction under subsection 1, it may include such conditions in the such directions in the light of the facts of the particular case that may think fit. A condition person shall make available. Malaj, I think this was in subsection 2 of 438 of the old code. 438 of the old code, Malaj, these conditions were there. Not leave India.
Yes.
This is there in subsection 2, Malaj.
Not in subsection 2. In subsection 1 itself.
2, Malaj. These conditions are in subsection 2 of the old code. Section 438, Malaj, first deals with that. Then, Your Lordships, there is a proviso.
Yes.
Then, of course, 1A was subsequently inserted.
1B.
1A, 1B was subsequently inserted, my lords, and then there was subsection 2. So this directly, subsection 2 is the same.
Yes.
3, my lords, if some person is thereafter issued without a warrant of an officer in charge, such acquisition is prepared either to conformity to court under subsection 1.
3 would be same.
3 is the same, my lords.
4 same.
I think 4 also is essentially the same, my lords. What is 65 and 70 of the IPC, the new IPC, BNS?
65 will be.
You see, now what is missing here?
Is, my lords,
only this part where
the proviso and subsection 1A and 1B.
Yes.
So,
this is Bombay High Court. Has Bombay been placed? Has Bombay been placed? Well, I think I'm grateful to my learned friend, Mr. Deb, who has also placed the Bombay High Court, because Bombay High Court has passed a very detailed judgment at para 73. They deal with bails. Your Lordships have it, Millets. This is squarely sits on our case, Millets. Section para 73, Millets. BNSS 2023 is admittedly a procedural law, mostly governing the inquiries, investigation, bail, trials, appeals, etc. As far as the application of bail is concerned, it is procedure to be followed under a specific act or code. Since the provisions of section 438 of the Code of Criminal Procedure and that of section 482 of BNSS are paramateria. So there is already a finding, Millets, that it is paramateria. The provisions of repeal would clearly apply to the matter in hand, and accordingly applications filed by the respondent accused persons on 6/7/2024 shall govern under the provisions of 482 of BNSS and not under section 438 of CRPC.
with due respect, I don't know whether you can call it paramateria.
Well, it's in substance it is paramateria.
In substance, yes. But
paramateria would only be in substance, Malaj. Yes. The words per se may not be the same. Only thing is, Malaj, that as your Lordships rightly said, that the proviso was removed.
But would that be, you see, now at this point of time, would it be advantages or disadvantages to the applicant.
In my humble submission, my lords.
Because now we all know, in common parlance, that the applicant would definitely prefers a provision which would be advantageous to him.
My lords.
So in case the old code puts a greater restriction and the new code...
That again is clarified under 531C, my lords. I'll take your lordship to 531C. That eventuality has been covered. I'm sorry, 531(3). What has fallen from your lordships is very pertinent, and the lawmakers have thought of it.
What does it say?
Your lordships have it, my lords. 531(3). Where the period specified for an application or other proceeding under the said code had expired on or before the commencement of the Sanhita, nothing in the Sanhita shall be construed as enabling any such application or proceeding to be commenced under the Sanhita by reason of the fact that a longer period thereof is specified by the Sanhita or provisions made in the Sanhita for extension of time. So supposing, my lords, under the new code, I have a better benefit, I have more time. Supposing earlier says, my lord, 30 days, this says 60 days. I would still be governed under 30 days, I will not have the benefit of 60 days. But insofar as 438 and 482 now, my lords, is concerned, they are parameter for the purposes of the exercise of powers by your lordships.
True.
That's one. Number two, my lords, the conditions that your lordships may impose in appropriate cases are provided under subsection 2.
That is, of course. That is.
And subsection 3 and subsection 4, my lords, they are parameter for the purposes of exercise of powers by your lordships. Now, what has been left out in the new...
See, Mr. Paul, for discussion's sake.
My lords.
Now, if this provision says, again, come back to 438.
The proviso, my lords. What has been left out?
Yes, what has been left out?
My lord, the proviso, my lords, is...
If it says...
In my respectful submission would be it is unnecessary because your lordships may read the proviso.
See, if it says that you have to take this into consideration, the factors of nature and gravity of the accusation,
lordships,
and so on and so forth.
My lords.
This portion is missing.
In the new Sanhita.
So it means that the court is not...
No, why it is missing is, my lords, that's because it was diluted by the Honorable Supreme Court. Your lordships are aware, my lords.
Of course.
Series of judgments saying that what was happening is, my lords, earlier when your lordships were passing orders under 438, your lordships were bound by that power.
Because you see, what has been, emphasis has been laid on the liberty of...
Absolutely. Thereafter, your lordships, the Honorable Supreme Court took a different view. He said that it is not only this. There would be other circumstances that would govern it, and your lordships would take a holistic view of the entire matter at the time of passing an order under 438.
Supreme Court has passed many judgments, even on the issue of bail conditions,
absolutely,
so on and so forth.
Absolutely, absolutely. So what has happened, my lords? This provisions of this 438, as it then was, my lords, has been diluted. So it is not necessary that your lordships would essentially have to look at only these factors and not other factors. So Honorable Supreme Court says that you'd have to look at take a holistic view of the entire matter, and therefore it was diluted. So lawmakers probably thought, my lords, it's best to do away with it. Now the proviso, your lordships, which has been done away with, your lordships may kindly see, in my humble submission, proviso was not necessary. Because proviso says that if your lordships do not pass an order, interim order, it would be open for the police officer to come and arrest me. It's a natural corollary. Then 1A, my lords, where the courts grant an interim under so-and-so, it shall forthwith cause a notice being not less than 7 days together with a copy of such order to be served on the public prosecutor and the superintendent of police. This again, my lords, in my humble submission is again covered by the Honorable Supreme Court now. Because under 141, again, the law will apply, my lords. It said that any application you have to serve prior notice to the public prosecutor. And without hearing the public prosecutor, your lordships will not pass an order. So this little element which was available, my lords, that I could come, move an application and subsequently serve, that has been done away with. And 1B, my lords, the present of the applicant seeking anticipatory bail shall be obligatory at the time. This again, my lords, has been diluted by the Honorable Supreme Court. So which is why the law as of today has culminated into what it is, my lords. And which is why I would again, my lords, reiterate that probably the finding of the Honorable Bombay High Court to that extent is okay, correct. Because, my lords, the power being exercised by you, by your lordships under 482 or 438, my lords, is parameter.
Yes, Mr. Anything?
My lord, as far as this 438, 482, in the two different courts, my lord, I do not think, my lord, these two are similar provisions. There is a vast difference as far as the wordings and meaning of these two sections are concerned, my lord. Therefore, my lord, my only submission is that, my lord, as far as old cases are concerned, where the investigation is pending, and that has to be continued in terms of section 531 2A in terms of the CRPC, my lord. That is my only submission.
Well, I am not disputing that,
That
what my
is-
learned friend is saying.
See, that is the general perception, which can we are of course, it may be necessary, it may not be necessary, but we go into the nitty-gritty of it.
What I'll try and assist your lordships with, my lords, is where the honorable, the full bench of the apex court in Gurbakh Singh, my lords, which culminates into Gurbakh Singh, where they say that where is the source of power under 438. That will settle the matter.
I understand your point.
My
What
lords.
you're trying to say is
That these are special powers.
This is a standalone provision.
It is not, my lords, essentially part of the procedural law. It is a standalone provision, because what the Honorable Supreme Court decides is, my lords, is that bail, the concept of bail is when there is arrest, there is bail. Now, courts, because of the circumstances, my lord, had to come up with a situation where prior to arrest also, your lordships are granting, in apprehension of a certain arrest, my lords, your lordships are granting bail. In normal circumstances, my lords, we say that it is premature, your lordship say that when it happens, you come before
That
us.
principle and proposition is well settled.
So once that is there, my lords,
we are on the procedure now.
no, once that is there, my lords, I am saying that this is a standalone power. And as Honorable Bombay High Court says, my lords, it is a power that is exercisable by your lordships under a code. The court has to enable your lordship to exercise that power. CRPC as on today does not exist. It is not part of a trial. It is not part of an appeal. It is not part of an investigation. So once that happens, my lords, your lordships will exercise independent powers.
Once it is repealed, it does not exist.
My lords.
But we do have, again
Savings.
we are repeating ourselves.
No, my lords.
We
Savings
do
is
have a saving clause.
savings is in respect of the trial. What my learned friend is repeatedly saying.
Investigation also.
Investigation trial.
And
438 is not subservient to an
It
investigation.
says applications.
My lords, 438 is not subservient to an investigation.
We are on applications.
Absolutely. Application, and this is a special power that is being exercised, so it has to be under 482. Because 438 as on today does not exist. What I'll do is, my lords, those entire judgments with a small note, we'll try and supply it to Court Master by tomorrow.
In fact, all the parties are, you are free to do so.
My lords.
It would be helpful for the court to.
We'll also try and, my lords, draw up the genesis of powers.
Go through all these bundle of judgments.
My lord, we also relying on the same judgment, Delhi and Punjab, and I have already supplied the copy.
Yes, you present your point of view. Mr. Shulai also can do the same. Where's Mr. Shulai?
I think, my lords, he's on legs somewhere else. Obliged.
And similarly, would you?
Obliged, man.
Mr. You can also do the same thing. Just, submit a brief note on your submission and
till item 7, my lord. We'll be doing the same thing.
Please.
Consistent position.
How soon can you do it? Tomorrow?
By tomorrow. The lordships have heard us at length. So, and my lords, I was thinking it's a bit too late. Because we were hoping, my lords, that a judgment will form from your lordships. And then the rest of the courts across the country will then consider Meghalaya's view.
Meghalaya is always the younger brother.
Sometimes, my lords, the decisions of the younger brother prevail upon elder brothers. They've had the benefit of, my lords, having had the guidance of the elder brothers.
We have to respect propriety.
No, they have the guidance of the elder brothers, my lords, so therefore their decision may be more balanced. That's all I'm saying.
That's on a light note.
Grateful.
Till 7, my lord, we'll be doing each of us.
So all the parties involved here.
On the preliminary issue.
As far as Mr. Day and all those who are, party to, who are, who have filed their application here, you can do so. Are you?
I'll be also
this gentleman here?
They are with me, my lord.
They were here. Okay, so you can do that.
You're also on the BNSS.
Yes. No. I'm in the old.
Acha. My little friend is on the other side. Obliged.
So we do that. So we fix this matter tomorrow.
Tomorrow, submit the notes.
Deeply obliged.
Heard learned counsel for the parties who have advanced their argument on the issue of whether the whether the old code, that is the CRPC 1973, or the new code BNSS 2023 will apply as far as bail applications are concerned, including pre-arrest application for pre-arrest bail. On conclusion of the submission of the parties, it is submitted that a brief written synopsis of the argument may be allowed to be filed along with the authorities relied upon by the parties. Accordingly, on pre-admit, the same is allowed. This matter tomorrow.
Hello, authorities have already supplied, so may I just refer to them in the video?
Yes, you can do that. When I'm saying that, you have already supplied, but in your written argument, you just record them.
Till 7, my lord.
Yes, till 7.
Till item number 7.
Yeah.
Deeply obliged.
Item number 8.
Please, Your Lordship. Lordship, the conducting counsel, Mr. SN, is on next, my lord.
Yes, so what do we do?
My lord, if the matter can come after 1 week, my lord, subject to Your Lordship's convenience.
On pre-admit by the petitioner, on pre-admit by Mr. Leonard J. appearing for the state petitioner, seeking accommodation on the ground that the Leonard conducting counsel is indisposed. That is adjourned. This is up to 1 week.
Deeply obliged.
Item number 12.
Please, Your Lordship. Your Lordship, here the conducting counsel is indisposed. If this matter may be taken up after 3 weeks, Your Lordship.
You have a petitioner?
Yes, Your Lordship.
But here, I think we are only on the production of records.
Your Lordship, the conducting counsel is indisposed.
No, who's to produce the record? You or
the petitioner, I suppose.
No, it is for the state to produce the record. So why would you
I apologize.
take the plea of the Miss Leonard counsel for the petitioner has sought for time on the ground that the Leonard senior counsel who is conducting the matter being indisposed. This court, by order dated 16/7/2024, had noted that the relevant records are to be produced for this court by the state respondent. However, none has appeared on behalf of this state respondent 124 and the bracket 124, and the records as called for has not yet been produced. The state respondent is accordingly directed to produce the said record on the next date fix. As prayed for, this is matter to. Why 3 weeks?
Your Lordship, the conducting counsel is indisposed.
This is matter to 3 weeks.
Highly
Item number 14.
So you start first. Yes, let him. Page. You're done, sir? Will you reply? Last time you finished, sir. Should we reply?
No, I've yet to start probably. No?
Yet to start, sir.
Finish first. Why you need these books for? Yes, Mr.
Be pleased, Your Lordship. I would invite Your Lordship attention to the page 54 regarding the sale deed.
$54.
54, my lord, and it's your 10.
Yes.
Read by respondent. Respondent number 5.
Yes.
In favor of respondent number 4. In favor of respondent number 4.
Yeah.
Read, my lord. This deed of sale is made on the 30th day of June 2020 between Ankurstad Kempat and Romario Sunga, and the area of the scheduled property, my lord, is in page 58. All that piece of land situated at Kli Lamanang, That Mari village, Namdong, is like East Ilakan Nangjingi, West Gentia Hill District.
Yes.
North, East, Southwest have been given, my lord. This sale deed on the face of the record, my lord, apparently there is no area.
Yes.
There is no area, and it is an unregistered document, my lord. On the basis of this sale deed, my lord, an application was made before the district council, before the revenue officer. Page. Page 7 of the affidavit, my lord.
Page?
Affidavit, page 7 of affidavit of respondent number 1, 2, 3, my lord.
Page
7. One, two, three. I mean the district council.
Oh, district council.
Translated copy in page 7, my lord. This is in series, there are 4 of them.
Application for land holding certificate.
Yes, my lord.
Just a moment.
The first application is
Just a moment. This is 1, 2, 3, and 6, no? Respondent 1, 2, 3, and 6.
1, 2, 2, 3. 6 and 6, yes, my lord. And
yes,
and in this application also, my lord, there are no area, my lord. There are no area. And this application was submitted to the District Council, my lord.
Yes.
My lord, the District Council, through the Land Record and Settlement Officer, that means respondent number 2, I think. 2, yes, 2. Respondent number 2 has informed that English translation is in page 65, my lord.
65 of?
Of the petition.
Your petition?
Of the affidavit. Petition. Of the petition, my lord.
The petition.
Of the petition. Annexure 12. Annexure 12.
Yes.
The English translation has been also given, my lord. With regard to the subject mentioned above, I am to inform you that after proper scrutiny and examination of your application, permission is hereby granted to cancel the pata number 2418/2400 Ilaka Nongjingi, known as Kli Lamarang, and at the same time, opportunity is given to you to apply for land holding certificate for the land. The area of the pata is 4548 square meter, my lord. So this is the area that the respondent number 2, Land Record and Settlement Officer, allow the respondent number 4, Romario Sungo, to apply for land holding certificate for this land, 4548, my lord. Then the irony, my lord, is that out of these 4, he has made 4 applications of land holding certificate, my lord. Out of this land of 4548 has made 4 applications, my lord, for the land holding certificate. The area.
It means that this whole this area of 4548 has been divided into 4 parts.
It appears to be. It appears to be that because
intention.
you make like that. Out of this, the permission allowed by this. By the District Council, my lord, respondent number 2, through its officer, respondent number 2, is 4548. And out of that, he has applied 4 land holding certificate, my lord.
In his own name or in different names?
In his own name. In his own name.
Where's the application?
application, my lord, is in page 95 of our petition, of our petition, 95. And Annexure 22. And in Annexure 22, my lord,
Yes.
it is a landholding certificate issued by the district council, my lord. Landholding certificate number 39 of 22, certified that according to the customary right and holding and by virtue of so and so, fully described in the schedule below, to Shri Romario Sunga. And the area here, my lord, is 2,22,119 square meter, my lord. So, my lord, out of that 4548,
So how can it be? You said that out of 4548, he has applied for 4 land holding certificate.
Yes.
In his own name.
In his own name.
One of those certificate is this.
Yes, and what is
This
the area?
This area is far greater than.
What the entire dispute has arisen because in that Bill 65, the area is mentioned as 4548 square meters. There is a typographical error. In fact, it is 45.48 acres in all the other documents. That is why this issue has come. If Lordship will see, the original landholder had a patta, 45.48 acres. That was mutated in the name of the seller, which is respondent 5, 45.48 acres with the same schedule. Now the sale deed which was made between the seller and the buyer of the same schedule without mentioning the area, but it would be safe to assume that it would be still 45.48 acres. Now when he applied for applying for the landholding certificate, possibly because of a typographical error, instead of writing 45.48 acres, it became 4548 square meters, but it's a huge difference.
This is respondent 2. He is respondent 2. Romario.
No, he's number 4.
4, my lord.
I'm for the, yes, my lord. What happened, my lord? If my lord
Is that correct?
Yes. Now, if my lord may kindly come
Now-
to page
now,
65.
see, Mr. D,
My lord.
If you have applied for a land holding certificate as at page 65,
My lord.
the area that was indicated there was 4548
My lord.
square meter.
Yes, my lord.
So apparently that would be a typographical error.
Yes.
Have you applied to the authorities concerned to correct that?
Subsequently, it was done, my lord. Now, this is their letter. This is not our letter. This has been issued by the district council, my lord. My lord, if my lord multiply 45.48 acres into, if my lord convert it to square meter, then it's come to 2,22,119 square meter. And the other 3 also, my lord. Because the land, my lord, is calculated.
Yes, okay. Mr. Kinjing, if that is the case,
I'll explain, my lord.
Whether you see whether it is a typographical error or
No. It is
according to you is not.
By saying no, it will not change the scenario in the record,
Okay,
my lord.
I'll change. I'll tell you.
I will change.
Land holding certificate, my lord, is specifically given the pata. This pata right from Assam time was issued under
just a moment.
Under the Assam Land Revenue Regulation. And what is the area of that pata? What is the area of pata? Pata is that much only for. Yes, 45.48, my lord.
Yes.
Yes.
That is what we are saying, my lord.
Yes.
45.48
Yes.
acres.
Not acres.
Let us see, my lord.
There is no such thing as acres at that time, my lord.
Now, my lord,
What is the calculation of
they don't.
area?
My lord, the pata is issued. If you all this pata is issued in Assam and in Meghalaya also the same way only.
Yes.
Then it is in hectare, areas and centiare. It was given 45 areas.
Acres.
And then 48 centimeter, my lord. And 48, it comes to 4,548 square meter, my lord. One area, listen, I'll explain to you.
What is that areas?
One area, my lord, is equivalent to 100 square meter.
I've never heard in the geometry or any
Just
mathematical calculation.
We'll come to that. You
It
can.
is not a general name. You check the calculation. The calculation, my lord. Only.
Yes, one areas is one.
Yes.
Is 100 square meter.
Yes, and let them check there also the chamber dictionary. What is areas? Areas is the unit of measurement, and one area is equivalent to 100 square meter. I know because it is right from July. In the district council, this is the system.
You have a copy? Give it to them.
And this.
Where is where in your petition is the reference to this areas?
Yes. No, my lord, that is the area.
Oh, area.
The area here. The area. This is not the.
So 454. No,
4548 is the.
45.48 areas.
It's the area. It is not a.
But they say acres.
Not acres. It's not acres. It can never be in acres.
Okay, whatever the case may be.
My lord.
Whatever the case may be.
Let them produce original pata and consult the district council. Let them come forward with that. It can never be in acres. That's why I went out from the.
But why would see in page 90, 95, is it?
The landholding certificate, my lord.
Landholding certificate.
Why was this 222 square meter was indicated here? Because here you see, Mr. Kanjing, if the area is given as 222,119 square meter, which is equivalent to 45.48 acres. That's what he said, isn't it?
No, my lord. Yeah, plus 3 other. All the 4 portion. There are 4 portion of land, my lord. This is one portion.
Okay.
One portion. Adding the other 3, my lord, also is there. What I will submit, my lord, here. Let the district council produce the original record.
Yes.
If it is 45.48, my lord, then my lord senior should not have any objection if it is an acre.
In that case, let them produce, my lord.
Who's paying for this council?
Let them produce first.
Your Lordship, if the records are to be called, that means the Lordship is going into the
merit of the case.
Yes.
My
Of
humble
course,
submission.
of course. We are, see, as this court has made it clear that the maintainability as well as the merits would be looked into.
Yes.
But since there is a confusion created here, could be because of typographical error, could be because it is actually a fact. So we don't know. Now, it has come to, I'm not so good in maths, but it has come to me about the term errors.
My submission will be, my learned senior may have a very good case, but not before this court.
True.
Maybe before the trial.
This court will decide. If it is a question of disputed facts, that also will have to be.
The moment it is 44.5 acres or areas, that become a disputed facts, my lord.
Exactly.
It has to be adjudicated by the trial court, my lord. Moreover, my lord, why they have come before this honorable court, my lord? The background of the case, if I can just highlight, my lord. This matter
is their case or my case, my lord?
No, my lord, I also have the right to place my argument, my lord. Now, my lord, they are saying call for the record. The moment my lord call for the record, I said yes, it will clarify. But the objection raised by the other respondent, they say that alternative remedy is available to them, my lord. Once there is a statutory remedy.
That is why we are going to the issue of maintainability.
My lord.
So again, I'll repeat myself. This court will take a wholesome view of the entire matter or the dispute within parties, if that is to be ascertained,
Yes.
it may take into the same into consideration or not. That's a different matter.
My lord.
It could just be for the satisfaction of this court. Eventually, the locus of the petitioner would be decided, and if we are treading on the area of abundant caution.
My lord.
If they succeed, then to go back into and hear the parties on the merit would be a waste of time. But if the whole issue is heard, including maintainability, if they don't have the locus, then that still we don't go into the any other aspect of the matter. Simple as that.
Whether this petition is maintainable or not, my lord, my learned senior has to answer and satisfy this honorable.
Yes,
He says that to decide on the issue of maintainability, the merits has to be decided,
Yes.
has to be discussed first, and he's launching into the merits of the matter. But in the course of of
The
argument,
terminology my lord has used, that was very common during the Chandrayaan, while launching pad, my lord. He is in the launching pad. He is launching his case. My lord, he can argue.
let's assume for a moment, let's assume that your submission is correct as far as the calculation is concerned. Then we will look into it. As you proceed with your counter, then we'll proceed. If records are required, so be it. If not, it will be decided.
That's my submission, because under 226, will your lordship go into how much is the extra, how much
No, that would not.
I'll explain all those things.
but-
I'll argue all those things if
You
you
know
want.
very well,
me.
Mr. No, you know very well. You have to educate me on this. But if I understand correctly, the High Court under 226 can even go into issues of facts.
In a very peculiar situation, only my lord can go into that, can cross that limit, my lord.
Exactly.
Otherwise, this
If it is
court, my lord-
warranted, if it is
for this
warranted.
particular case?
But because the area, my lord, now
It is
area,
the-
now whether it is an acre or area, my lord.
Nobody can see that. I'm not the authority,
My lord.
and you're not the authority. So we'll have to go to the authority. That is the
Yes.
district council.
It is the record will speak by itself.
It is not a question of alternative relief.
And appeal also is there.
Provided under the regulation. He has to exhaust that.
Exactly. That would be your ground as far as maintainability is concerned. So let him satisfy that. Don't jump the gun at this point of time. Please continue, Mr. Kanji.
My lord, I'll invite your lordship attention to page 25 of the affidavit of the respondent 1, 2, 3, and 6.
Page 25.
25, sure. Okay, 1, 2, 3, 4. And 4 also, my lord. And in page 25, my lord,
yes,
it's very clear.
Yes.
This is their document, my lord.
Yes.
In page 25, my lord, area of the paddy field.
Yes.
HAC 045 areas 48 centimeter, my lord. Clear Lamanang. It's very clear. This is from the record itself I'm speaking. It's not from the
Which
insane.
affidavit, sir? Whose affidavit?
4.
Respondent number
This-
1, 2,
page-
3, and 6.
Page 25.
25.
To the revenue officer.
Yes, through the 1, 2, 3, 6.
No,
And
this
4.
is Annexure D.
No, annexure page 25, my lord, is a
Yes,
translated
page
copy.
25. Translated copy. Office of the Dollar Ilaka, Nongjiri.
No, my lord.
Annexure 1, my lord, may kindly come to Annexure 1, page 25, my lord, is a
25.
typed copy and translate copy. And R4, my lord, is the respondent number 4, my lord. My affidavit, my lord.
Oh, respondent 4, yes.
Yes, respondent number 4, my lord.
I was referring to respondent 1, 2,
And
3.
4 also, my lord.
6. Just a moment.
Page 25, my lord.
Just a moment. 4. Page 25.
25.
My lord, may kindly come to my affidavit.
Yes,
I have filed on 10th March 2023. R4.
So many papers are here. I don't know what is what.
Gender affidavit doing gender. In the affidavit in a portion, my lord, of respondent number 4. From Mario Songa. Is your affidavit idea, sir?
Yes, sir. What do you want to show, sir?
When you show who is this, what is this?
After hectare is acre comes, no, sir? After hectare.
Aries. This is Aries and this is Cynthia. 1 Aries is equal to 100 square meter. We don't know that, no, that's why I know. I am from there and I transferred the So my lord,
just a moment.
This is when they change the name of in the pata, my lord.
This is the
Or Mario.
application for changing of name.
Yes.
Name pata.
In the application for pata. This is from the record.
Yes.
Yes. And this is the pata.
Yes.
They have enclosed there. The area is 4 hectare Aries centier. 45 Aries, 40 centiers. Of course, my landed friend, they are yet to, of course, anyway, they don't, this, yet to learn, I think, my friend. Otherwise,
I've never heard, my lord, after hectare, area comes.
Areas.
Areas. Okay, my pronunciation may not be
Not
correct.
area, not aka, Areas. A-R-E.
After hectare.
And this also, you didn't see the from the state of Andhra Pradesh. 1 Aries is equivalent to 100.
Land tenure system of Andhra Pradesh and Meghalaya is different, sir.
No, this is a land system right from the British time. Right from the British time. That's why Java is like that. This is Assam also like this. All Assam also like this. You don't know where you are from, Shillong.
Yes, sir. So you are saying that this is hectare, Aries and
Centius.
Centius.
Yes. So the area is only 4548. And out of this area, they have made so much claim, my lord, imaginary claim, my lord. And the district council respondent number 1, 2, 3, 4, 1, 2, 3, and gladly comply with them, my lord. So from that very on the face of the record, my lord, what more to say? It is not a clear case of that was not done correctly, and that is also on record. And we have given affidavit rejoinder, and that not only that, even the third mandri also has given the same, supported us, the same thing in their affidavit, my lord. Now, my lord, this is the affidavit of the third mandatory also in page, in paragraph, in
Respondent.
third mandatory is respondent number 7. 7. Respondent number 7. Affidavit in person on behalf of respondent number 7, third mandatory village.
Where's the affidavit of respondent 7?
Affidavit in person on behalf of the respondent number 7, the third mandatory village.
Page. Page.
The paragraph number 11, my lord, page 3. That with regard,
yes,
that with regard to paragraph 14 to 29 of the writ petition, the answering respondent begs to state that respondent number 5 is an owner of only a plot of land mentioned in Pata number 2418 and not beyond the area of the said Pata, and as such, the alleged buyer of the land, that is the respondent number 4, can only be the owner of the area mentioned in Pata number 2418 and not beyond, my lord. As such, when the representative of the third mandatory village was informed by the representative of the Namdong A village about the attempt of the respondent number 4 in collusion with respondent number 5, to obtain landholding certificate beyond the area mentioned in the Pata number 2418 and in the area that is jointly used by Namdong A village and the third mandatory village, which fall under third mandatory village, the representative of third mandatory village had an understanding with representative of Namdong A village that Namdong A village will file necessary objection before the concerned authorities of the Jaintia Hill Autonomous District Council, JOI, and that third mandatory will provide the necessary support. Accordingly, the Namdong A village proceeded to file the objection. Later, a representative of the third mandatory village was informed by the representative of Namdong and so and so, and that respondent number 4 has claimed that the notice is required to be sent to the Wahid of third mandatory village for the purpose of public announcement with regard to the desire of respondent number 5 of procuring land holding certificate in the area beyond the Patalpur has already been received by the headman of third mandatory, and the necessary public declaration was made, my lord. Then the next paragraph, my lord, however, to the shock surprise answering respondent, the respondent district council authority, despite the objection from Namdong A village as well as that of third mandatory village, the said authority went ahead and issued a landholding certificate in favor of respondent number 5, my lord. However, to the shock and surprise of the answering respondent, the respondent district council authority, in spite of the objection, went ahead and issued a landholding certificate in favor of respondent number 5. It is pertinent to point out that, as pointed out by the petitioner, in the paragraph 28 and 29 writ petition, the area is apparent from the landholding certificate issued in favor of respondent number 4 far exceeds the original area mentioned in the Pata number 2418. That's in the defendants awaiting the outcome of the writ petition. In the event of the writ petition is not maintainable and that there is an alternate forum, then answering defendant will take necessary recourse, my lord. So that's why they have, on the face of the record, my lord, it is a clear case that the authorities fail to act. That's why the writ has been invoked, my lord. That is the purpose, with due respect, my lord. The writ petition is meant to for this type of thing, my lord. This illegal act of the authority, my lord.
You have come for, you see, you have come for a mandamus. So we'll see whether it lie or not.
Yes, yes.
Anything else?
Just a minute, my lord. It is on record, my lord, that we have made a multiple objection. We even requested for survey, and that has been in page 70, my lord. We have even requested for resurvey. They have not done. Multiple objection in page number 6. Multiple objection, my lord, in page 66.
Yes.
And there, my lord, in the we have specific objection has been filed by and received to the address to the respondent number 2, the record, the land record and settlement officer. Complaint against the survey for converting the Pata number 2418 to the landholding certificate affecting the boundaries of Namdong A village, Namdong A village right Namdong, Irakanong Jigi. With reference to the subject mentioned above, I understand representing the Dabashang, I'm filing the complaint before your office against Ankur Star Kumpan, resident of Mogondo of Minskat, regarding the survey of the land along with representative from your office with informing so and so, my lord. And without taking into consideration the complaint filed by the Darbashang. The land is situated at Minsing, Madan Tarbubi, and in view of the above, we request you to take necessary action to bring peace and harmony in the community. This has been sent by the petitioner, my lord. Yes, the Wahayasang of Namdong A, my lord. And agreement.
What is the response to this letter?
Nothing. We have not done anything.
You have not filed reminder?
But we used to go every now and then to the office. Nothing. Then, my lord, even in the to the revenue officer also, George, hello, Jumbum Le village code Ilakanongji. And Vilika Ilakanongji, as a matter of fact, he is a chairman, and at the same time also he is the one who recommend all those landholding certificate also of the imaginary area, my lord. And it is on record, my lord, that there is an agreement between the third Mandri and the district council to preserve the forest land in the whatever forest outside that 2418 for the sake of preservation of the forest and also some for cultivation. But that also, in spite of all those things, my lord, still the District Council does not pay any regard, my lord. Respondent number 3. Reminder, first reminder. There is a reminder also, my lord, in the page 78. My lord, is a complaint against inaction of the village court Ilaka as per notice so and so. With reference to the subject cited above, we understand are filing a complaint before the court office so. Then, by not, on behalf of the village, we strongly object to the responsible behavior of the Deloitte. That means the respondent number 7 or 8. On
page number? Respond
78.
78.
Then, in view of the above, we representative of the village kindly request your court office to resurvey the land as per the name in the pata, my lord. But that also was not done, my lord. On the other hand, agreement. Ini ambil lagi. Ini petition. As a matter of fact, my lord, there is a agreement, a resolution between the village, the Darbasnong, Namdang, and Thatmandri also. Prior in 2019, my lord. 2019. The joint village Darbar of the Namdang A and Thatmandri, my lord.
You are referring to whom? Page
52, my lord, of the petition.
52.
52.
Yes. What is this? This is agreement for?
To preserve, some to preserve, some to like
What?
not to allow cultivation of broomstick and some place to be for cultivation like that, my lord.
It has got nothing to do with the land in question.
Yes, that means it is. It has nothing to do. It is beyond that 2418. 2418 is a pata.
Yes.
Pata means a hilly land. That is a yes. Pata is meant only for the hilly land. Landholding certificate is meant for the land, my lord. That's the thing. So this the respondent number 4 or 5, they have made it that pata, they change it to application of landholding, and that in 2418, that area of 48 point something, my lord, 45 point something, they make it they make it an acre, my lord. And that acre, and then they divide it like this. So in view of that, from the first record is that it is not a question that this is a question that the state, the authorities fail to act, my lord, in spite of the fact of complaint by the village, by the people of Namdang A and Thatmandri, my lord. This is a case, my lord, of inaction of the authorities, my lord. So as such, my lord, the the writ petition apply, my lord. When the authority fail to act, it is their duty bound to act. Because what is duty bound of the revenue authority, my lord, is to check the land, to calculate, and the area how much, and the payment also how much they have to pay. Because in all the pata they have to pay specific revenue, my lord, to the district council, my lord. So, my lord, my question, my submission is that those 4 pata, my lord, is to be set aside and quashed, my lord, on the face of the record, because it does not tally from all uncle, my lord, as per the record. If your lordship is pleased to call for the record, you can see very clearly from the record itself also that it does not tally.
Yes.
My lord, senior.
We'll continue.
I'll come to the.
Yeah, you finish.
No, regarding the citation, my lord.
Okay. Now it's already 1:30.
Continue one other.
Now you are on law points.
If your lordship feel it, we can continue also another day.
After 1 week.
So the district council now. Let them consult the district council.
Can I pray for on 3rd, my lord? Next week probably I'll be out of station. I'm going to Delhi for one matter, my lord. So can it be on 3rd of September, my lord? I'll be back.
What, Mr. Yes, can you learn it, senior counsel, appearing for the
So the petitioner will argue on the law points only, then he will reply, my lord.
He will.
Anyway,
That's
law
what.
point also. Everything is getting law, no? Those things. Those things are not law.
The matter is. The argument is yet to be concluded and will continue on an exit fix. As agreed to by the parties, this is matter on 3rd.
3rd. Hello.
In the meanwhile, I can get further instruction.
In fact, I'm still, first you have to get instruction as to what was the prevalent method of measurement that is used or that is adopted. Whether there's some would adopt the kind of a regulation kind of thing. Whether we have the Assam regulation, whether it would be applicable or not, and what is the precedence there. All these things have to be.
It has
But
to
now
be under.
we are not clear as to whether it's arrests or acres or hectares.
Assam Land and Revenue Regulation will come into play, my lord. Which was under Assam at that point of time.
Yes. It would fair enough. According to Assam, that.
So we'll look into that.
Not to confuse with arrests and acres.
But it's education for us.
But the best part about my learned senior has said, my lord, you don't know because I am from that area, I know.
Because they don't know also though. It's not the best part. Because they are completely
ignorant.
Unfortunately, I have to use those words. They don't know.
We are open-minded, my lord. We learn from our seniors, my lord. We learn, and he's the senior most now at present, my lord.
Thank you.
Item number 15.
Yes.
Regarding this RPS matter,
I was informed, Your Lordship, the other side would make a mention.
All of you are not inclined to take up. I know very well. But just we think of who will build the cat. Pray made by the parties. This is matter of the 3 weeks. Your senior will be coming by then.